My guests are seated, and we are ready to do business to the issues that we have tabled for discussion this morning. My guests are Abdul Malik Kwekubako. He's the editor-in-chief of the New Crusading Guide newspaper, and he's our regular panelist. Dr. Evans Agri Dako. I'm always very excited to have him in our studio. He is lecturer, Department of Political Science, University of Ghana. He does more than that. Felix Kwachi Ofosu is Deputy Minister of Communications, and Nana Komia will join us. He's already in the studio, getting ready to take his seat. So we will begin the discussions, but we'll go to the phones to also speak to David Asante Boateng. He is the convener of the Let My Vote Count Alliance. They have some issues, and we'll let you know why exactly. If we are lucky, we'll get the EC to speak to us briefly about the new claims that are coming up as far as the issues we have tabled for discussion are concerned. Gentlemen, good morning and welcome to Newsfile.
Good morning.
Great to have you, as always. Now, the show is brought to you by the kind sponsorship of Bank of Africa, strongest group and close as a partner, MTN. Welcome to the new world. Star Assurance, creating smiles since 1985 and celebrating 30 years of solid partnership. And IIT, bringing people and computers together successfully. Having mosquito coil, Heaven, Obotantim, Accra Compost Fertilizer, you need that. And White Temple Agency, a luxury you can afford. Let's begin with David Asante of the Let My Vote Count Alliance. Good morning, David, and welcome to Newsfile.
Good morning, Samson, and thanks for having me, sir. Great.
I'd like us to do this, and very briefly, you go to the main point why you now suggest the Abu Ramadan and Evans Nemako have been back to the court, seeking further directions and some clarity to the judgment of the court on the 5th of May, ordering the Electoral Commission to delete or clean the register to bring it to compliance with the Constitution and the applicable laws of Ghana. Of course, we all know the confusion that has greeted that particular judgment and the interpretations that have been given to that judgment. Now, the court on Thursday made some further directions pending its decision on the application that is before it now. And the court said the EC should compile a list of NHIS registrants who use their NHIS cards to register for the 2012 elections and voted. Should compile a list of these people and submit same by the 29th, on or before the 29th of this month. In addition, the EC should, in writing, state the modalities, the steps, the roadmap it intends to use to implement the decision of the court, which was to be done immediately. The EC says, we have heard the orders of the court, we have no option, and we can assure Ghanaians that we can make that list available or meet the request of the court. We may even beat the deadline they are asking for. And I'm referring to the EC's, one of the deputies, Amadou Sule. We have also heard the EC's own PR, Public Relations Officer, or Public Affairs Director, confirm what Amadou Sule has said. You Let My Vote Count Alliance. You held a press conference, or is it yesterday, and you said the EC is lying. It doesn't have the list, it cannot produce the list, or if it did submit a list, it will be a bogus list. What exactly do you seek?
Thank you, Samson. Let me say good morning to our listeners and viewers. And thanks for the opportunity too. Samson, the court order says the Electoral Commission should compile a full list of those who registered using the NHIS card in 2012. You may have noticed since then both the PRO of the Electoral Commission, Mr. Rejakpasu, and the Deputy Chairperson in charge of operations, Ahmedu Sule, have come out boldly to state that the EC has instructed the regions to compile the data and that they are determined to meet the deadline. This is good. However, it was a big shock to us, and I will explain. Remember something, that on Thursday, the court order was based on Madam Charlotte Osei and Ahmedu Sule telling the court in April through their lawyer that the EC did not capture the type of card that the voters used to register in its IT database. But that if they go through all the over 14 million registration forms called the Form 1A, they will be able to determine. Per the AG statement of case filed on July 18 as well, 2014, in the first Abu Ramadan case, she said, a broad section of Ghanaians or a majority of voters in 2012 used NHIS card to register. So we're talking about millions in this case, Samson. Now, this is why we are shocked that the EC is saying now, after 2 years since the original Abu Ramadan case judgment, is asking the regional offices to produce the list. The question is, what list? Because one, shortly after the judgment in the Abu Ramadan case in 2014, remember Abu and Evans are both members of the Let My Vote Count Alliance. We traveled across the country, visited over 50 EC district offices. And to our surprise, even those who still kept the Form 1A from 2012, there was no available, reliable record of the kind of ID people used to register. Because registration officers were not trained to capture the ID you use. And nowhere on the 2012 Form 1A was a copy of such available. In CI 72, it provides that you have to write the card you use, either passport or driver's license. Nowhere, Samson. The truth is, nowhere was such written. Samson, the truth also is that the EC commissioners should know this. I'm sure Mr. Ahmedu Sule, with the greatest of respect, also know this. And then the PRO and Madam Charlotte say that in the Abu Ramadan case number 2, the court ordered that the parties in the case should meet to find a compromise on how to clean the register. This meeting took place in the EC conference room on March 30th of this year. God being so good, the meeting was captured for the purpose of record, and that the audio has been played severally on several radio stations. I'm sure you must have copies. On that tape, the exchanges between Nana Santibedi Etuo and the two deputy chairpersons, Madam Georgina Opoku-Amankwa and Mr. Ahmedu Sule, they admitted the truth that they don't have the data. I'm sure something you are aware of this tape. They told the plaintiffs in that meeting, if you look at the latest Form 1A, which was used in the recent limited registration exercise, a copy of which can be found on page 25 of CI 91, the EC has amended it to provide separate columns for each of the 3 IDs used for registration. There is a separate column for national ID number, passport number, and driver's license. So something, this is the situation. Even if the EC employs 200,000 hands to go through the 14 million forms used in the 2012 registration, it will take them close to 200 years to complete the assignment. They won't be able to come
David,
up with
you were calling on the EC to immediately make that list or go through the process to delete NHIS registrants. Thankfully, you've got the court to make an order for that list to be produced for a purpose we can only speculate the court intends to effect. Now, the EC says, I am capable of producing the list. You say it cannot produce that list, and that even if it did, it would be a bogus list. What do you want?
Thank you very much, Samson. The solution is very simple. We have taken inspiration from the extensive pre-trial conference between the plaintiffs and the defendants, where Madam Charlotte Osei, Madam Georgina Opoku-Amankwa, and Mr. Ahmedu Sule, both told the plaintiff's lawyers that we do not have the documents. So when they go back to court to tell the open court we have the documents, in our understanding, they have either lied to the court or they have lied to the plaintiffs. So
David, hold on. You told the media not too long ago, specifically on the 22nd of May, you told the media that on the day of election, Ghanaians who believe in the sovereignty of our election will make sure we implement the Supreme Court orders. We will make sure over 4 million Ghanaians who registered with National Health Insurance cards are physically prevented from voting because the Supreme Court says they should get their names deleted from the electoral roll. How are you going to do that if you didn't have the list of these individuals? In fact, you said again that you have gone round the district offices and you have collected the forms and you were able to identify these persons. That is how come you made a statement that you will stop them physically. So what are you saying?
Thank you very much, Samson. I'm sure this gives me a better opportunity to throw more light on that previous statement. Samson, we took inspiration from the Electoral Commission, who was of the opinion the best way to clean the register was through exhibition. In any case, if the exhibition had the legal backing to clean the register, the EC was going to use a physical process. The exhibition wouldn't be a chemical or spiritual process, and that would disenfranchise persons anyway. So what we meant was that we were also going to implement the Supreme Court's ruling to the letter and make sure physically people were not allowed to vote because the Supreme Court had said so, because their names had to be deleted. That was
you must first identify a voter as being one who registered with an NHIS card.
Something apart from the fact that we are told the whole job may look cumbersome or Herculean, the point here is that the EC on a number of occasions has told us we do not have the form. And what we are saying is that we have visited some district offices where the EC officials are even struggling for space for these Form 1As. If we manage to get about 100,000 of them and the EC presents this to court and say there are 100,000 of such names, here they are. And we, the citizens of this country, are able to match 1,000 people to the EC office to tell the whole world, these are 1,000 persons who registered with NHIS card, but their names were not captured in the 1 million names the EC presented to the court.
Like the court said, and want us to wrap up, like the court said, it is the EC that has custody of these registrants. And so it is the EC that ought to produce them. When the EC produces them in court, what is going to be your counter to seek to suggest that what it is producing is not correct and ought to be rejected?
It is very simple. We have a collective duty and responsibility as citizens to scrutinize every single document the Electoral Commission will present to the court to make sure they don't lie to the court. If I am David Asante and I know in my heart, per my records, I registered with the NHIS card, and the EC presents a set of lists to the court, and I don't find my name in there, it crashes the further dented reputation of the Electoral Commission. So the point is, we are also monitoring. If I personally take the responsibility of talking to 100 persons whom I know in confidence, registered with NHIS cards, and the EC presents a list and their names are not captured, we can further make a case to shred the quality and the integrity of the document presented to the court. But there is a way out.
So can you now see that, before you get us the way out, can you now see that in the end, you are either likely to have the court say, since you say these people cannot be identified, then let's go on with the elections with the register in the manner it is anyway, or it is that you have a feeling that the Electoral Commission had told a lie to the court that it could produce the list so that the court would not order the ultimate, which you were seeking, a new register. And now you are hoping that you are somehow cornering the EC to the point that it will be asked to now do a new register because it can't identify NHIS registrants.
Well, something, the ultimate goal is never to corner the EC, but to set the record straight and then to bring the plain truth onto the table. We know it is practically impossible for the EC to bring documents that are non-existent. They do not have it, and they can't produce it.
What did you say? What did you say is the way forward? What do you say is the way forward? Quickly.
We believe the EC knows how it can fully comply with the court order to delete and give opportunity for people to register. The solution is for the EC to place a new CI before Parliament for 21 days, after which it will have the power to make validation mandatory. Already, they plan to send BVD machines to all police stations for exhibition. The EC can just make sure it makes it mandatory. In 2012, CI 75 made no verification, no vote mandatory. We can make no verification, no validation, no vote as well mandatory through passing a CI in Parliament.
Okay.
And we give the validation process
interesting.
legal backing.
Interesting. Your critics will say that somehow you are stealing your way to get validation, which was rejected by the court. Thank you very much, David Asante, who is the convener of the Let My Vote Count Alliance. And forgive me the vernacular of cornering, if you are not too happy about that. But I just wanted a way to present it more graphically. Thank you very much. Now, I'll continue with Nana Kumia. Nana Kumia, the question people are asking, very concerned people in the country are asking is, it looks like this is what the people sought. Of course, your party is aligned to that position, and they seem to be getting what they want. And all of a sudden, they are now the ones running around and saying, even what we wanted, which is being granted somehow, is an impossibility.
Well, Samson, thank you. Let me wish your listeners a good Saturday morning. Let me start by congratulating Mr. Abu Ramadan and Mr. Evans Nimakun for the tenacity they have shown in pursuing this matter since 2014. Now, the Electoral Commission's record, as far as cleaning the register in time for the 2016 elections, that record has been appalling, very appalling. From the way they treated the NPP's petition, where they said that they themselves on their own could not get a copy of the Togolese register, and the other issues that were raised by the NPP were simply just dismissed without any effort at all to go into the merits of the case. You look at the way they treated their own panel of experts' recommendations. Cast away without any consideration at all. Because the panel of experts had made definite conclusions and recommendations. The EC's own panel of experts, treated in a very cavalier manner. Look at the way they've treated the Supreme Court's rulings. In May 2014, when the Supreme Court ruled that the use of the NHIS cards, the health insurance cards, were illegal, were unconstitutional, way back 2014. You would have thought that a responsible constitutional body like the Electoral Commission would have sought from the courts the precise intentions and proceed accordingly. Since 2014, there was no action, no response from the Electoral Commission. Then the plaintiffs had to go back to court to seize more precise intentions from the court.
Can't you see a response from the EC in the CI 91, in which they took away NHIS registrants, NHIS card as an identification document?
If the Electoral Commission has responded appropriately to the satisfaction of the court, I don't think there will be the need for this latest ruling. So you go there, the plaintiffs had to go back to seek more definite orders from the courts. And in May this year, the courts came out with orders that were quite specific, that the NHIS cards, registrations, minors, people who have passed on, all of these are in the register and make the register not fit for the purpose of the elections. So steps should be taken to delete those names. And then steps should be taken to give those who can access legal identification to come back onto the register. This This was so clear. Obviously, minors could not come back onto the register. People who have passed on could not come back and be re-registered. It's only people with NHIS cards who can be given a second chance to register with a valid identification. Yet, the Electoral Commission, as usual, made some noises and said they already have a process going and they have their own mechanisms and all of that. So the plaintiffs had to go back to the court for the third time on the same issue. And this time, the court really is pulling the ears of the Electoral Commission. Says that, go and do ABC by this date and bring it to me to look at and give you further orders. So when you look at this sequence of events, Samson, the Electoral Commission has been extremely appalling and irresponsible in its attitude in getting a clean voters register. And today we are here.
The EC says that they are going to implement the orders of the court now.
But why did it take so long? That's my point.
No, they are ready. They are ready, and they say we are supplying the court what it needs. Why are we putting yet another, stumbling block in their way?
Oh, I don't think anybody has put a stumbling block. I think the point that was being made by Mr. Asante, if I heard him correctly, was that he doubted the availability of the records.
He's not alone. Lawyers for Abu Ramadan and Evans Lemako have stated same.
Yes, because Samson, if people have some doubts in their minds, they may have some justification. Look, I heard some tape being played on radio stations where recognizable voices were saying that they did not have the records. I heard the EC, one of the defense, I think in the 2014 case, they were saying that if the NHIS registrations were declared illegal, that was going to disenfranchise millions of voters. So there is some doubt. But if the Electoral Commission says that it has the records, and it could access the records by, I think, in another 2 weeks or so, 1.5 weeks, 29th June, isn't it? If they say so, 29th June is just around the corner. We'll all wait and see. But those who doubt that the records are there in the manner they should be, and that the records can be accessed properly, all those millions of voters, if they think there are any doubt, they have another suggestion that maybe there is a better way out, a simpler, shorter, neater way out, maybe to go by the recommendations made by the Electoral Commission's own panel of experts, whichever name you chose to call it. But short of that, if the
when you say the recommendation made by the panel, you are referring to validation.
I'm not even worried about it.
No, I want to be sure of the specific that you said was recommended by the panel and the EC ignored.
Well, in the panel's own record, which you've read here to us, they use words like cleaning, they use a word like validation. I don't want to...
I have read, quoted the court, not the panel. The court spoke about clean, delete and clean. And you are saying, I've read in the panel. I have not read the panel, so proceed.
No, I'm not saying now.
Okay.
I'm saying previous times, when the panel's report came out. Yes.
I get that.
Yes. They use words like cleaning, they use words like validation and so on. I wouldn't want to be bogged down by trying to find one word to describe what they said. But it was very clear what they had recommended. And they actually had drawn up a table outlining the steps that they believe should be taken. Now, people believe that those recommendations, clearly outlined in the panel of experts' reports, if followed, may be a neater, shorter way of getting this done. But if the EC believes that it can very clearly assess the records of the millions of people who came onto the register of NHIS cards, and it can assess them and present them in 1.5 weeks' time. So be it. I'm sure when the court gets that list and the court is satisfied that the list is in order, the court will then make whatever further orders that they believe.
Okay. Now, hold on briefly there. Now let's hear from Felix. What you say particularly when they appeared before court, and I want you to take that and proceed to deal with the issues that Nana has also brought up. When they went before court, Justice Badebe, this is what he had to say. He says, let it not be that we make a pronouncement and then we do not care whether or not it is complied with. If this nation gets into crisis, then you blame judges. We will not allow that to happen. This is Justice Badebe. And this was after a period of asking the EC's lawyer and the EC officials what steps had been taken.
All right, I'll come
and
to
they
that.
kept insisting on the lines of their counsel that they intended to do deletions of NHIS registrants, but using the applicable law.
All right, I'll come to that. I have my own views on that. And there are other things that have been attributed to some of the judges, which to the extent that they have not been disputed, in my view, are worrying. But I'll come to that. You see, Samson, let us cut to the chase on the matter. This whole thing is nothing short of electoral saber rattling on the part of the New Patriotic Party. You see, in the wake of the Supreme Court judgment in the election petition case, somehow the MPP came by a certain bizarre and strange thinking that some registrations that were done by the NHIS around 2011, 2012 allowed foreigners to get onto our register, and that their electoral fortunes going forward, especially in 2016, hinge on the deletion of those names from our register. That is the source of this whole brouhaha. That thinking is unjustified, it is irrational, it is illogical, and yet it has been presented as though it is the very thing on which the MPP's life in 2016 is hinged. Go back to the original claims they made about the register. You recall that they made 4 claims. They said there were foreigners, 760,000 foreigners. This was said by Dr. Bamia at the Alisa Hotel. They said that they had been able to identify 76,000 of them, which was 10%, and that in due course, they were going to make the remaining 90% available of people from Nigeria, sorry, I beg your pardon, Togo,
They've
Burkina
obviously
Faso.
abandoned that course.
I'll come to that. They said there were minors. And then there were people who had died, whose names were on the register. Eventually, when the EC decided to allow for a public discussion of these claims, you find that the MPP's presentations were so incoherent that they were unable to justify the claims they had made. They were represented by Mr. McMahon. Subsequent to that, when it was time for them to present that 90% evidence, they wrote Nicodemously to the EC that they didn't have that 90%, or they were no longer interested in 90%. The EC, please let me make my point. I did not heckle you.
No, I'm not heckling
I did not heckle you.
You left out some of the other claims. We had also talked about constituencies and districts where the increment between 2012 and 2008 and 2012 were 50%, 60%, and those were not probable.
Which was also confirmed by Samia and Nkrumah.
You see, no, but the point is that on what basis you don't make those allegations?
The figures were given.
No. And in what way?
Nana, make notes.
In what way? On the basis of specific evidence, did that contribute to their defeat or the victory of President Mahama in the 2012 elections? And every step of the way, you see that they have used agitations, street protests, name-calling, attacks, blatant falsehoods, accusations, all in a bid to undermine the integrity of the Electoral Commission and call into question any potential
they
outcome.
They have not used any unconstitutional means. So let's admit that.
Yeah, but we can also point out what we perceive to be wrong approaches to this matter. No less a person than their flag bearer has stood on the platform in Amsterdam last year and claimed that the Electoral Commission and government were in cahoots to rig the 2016 elections, and that if there was violence, the international community should not sit down and ask how it came about.
This
that they should intervene.
This is not new.
It is not new, but I'm only establishing the premise of a certain pattern of behavior, which points to an effort to dispute the 2016 elections. Now they've got persons affiliated to them. And why? Only the uninitiated would believe that the Abu Ramadan and Evans Maku case is independent of the MPP. I am absolutely certain that they are there on account of the interest of the New Patriotic Party. Let My Vote Count is an offshoot of the MPP. Now, you and I know David Asante. You know exactly what he represents. It is an MPP grouping that has been formed to pursue this agenda. Now they go to court.
I don't think Abu Ramadan is a
Please.
member of
Yeah,
the
he is not, but I am saying that he is there in your interest.
Oh, okay.
Yes, I'm not saying he's a member of the what call MPP.
You have determined his.
Yes, I reserve the right to
But
make a
you
deduction like that.
You understand that it is even possible for one to belong to a political party.
I agree.
And yet belong to a group.
In fact,
belong to a group that is pursuing a non-political agenda.
It is allowed for the MPP itself as a party to go to court to do what is happening. Okay. So except that sometimes they try to be too smart in a bid to sway unsuspecting members of the public on their side. But the point I'm making is that they went to court.
Particularly your claim against Abu Ramadan.
But that is a fact.
It's unfair.
It's unfair.
Well, I hold the view.
It's unfair.
Abu Ramadan is a known political operative. And based on his commentary, his posturing, and what he does,
he's been a leader in the PNC
deduce exactly what he represents.
Okay,
it is not an unfair. But the point is that they go to court in 2014 to ask for pronouncement on the validity of NHIS cards as a means of registering.
Right.
Mind you, those who registered with NHIS cards did so on account of lawful procedure.
CI 72.
The Supreme Court says, yes, it is unlawful. So going forward, even in the limited registration that was done recently, NHIS card was not admitted as a means of identification. And that corrects the point that Nana Kumia made, that the EC had not acted on the Electoral Commission's pronouncement in 2014. And you pointed out CI 91.
He was referring you to what the court feels.
No, but this is
because the court feels
that
it did not do well.
I'll come to that. I'll come to that. But the point is that as far as the pronouncement in 2014 is concerned, the EC has acted because NHIS cards were no longer admissible.
But if you also listen to the judges, some of the judges, the EC has not done well as far as the 2014 judgment is concerned.
Well, that is in dispute, and we can debate it. Again, they go for this particular ruling, the second Abu Ramadan case. Just after the ruling, counsel for Abu Ramadan, and Abu Ramadan himself indicated that they will be going back to the Supreme Court to seek further direction and clarification. That suggests that there was some ambiguity about the rulings and the order that the Supreme Court gave. So if there was ambiguity, all that needed to happen was for them to go back and get the Supreme Court to make perhaps a more definitive pronouncement, which puts it beyond doubt exactly what is happening and exactly what they expect the Electoral Commission to do. Mind you that after that ruling, the Electoral Commission issued a statement indicating that they respect the ruling of the Supreme Court and that they themselves were taking certain steps to achieve what the Supreme Court was asking. Indeed, they suggested in that statement that the Supreme Court ruling is actually in line with what they were already doing. I am told, and it can be disputed if anybody has contrary facts, that this matter has been discussed at IPAC, where a roadmap for undertaking what the EC does every electoral cycle anyway, that is clean the register, was in place, and it was being done.
Deletion of the name.
Now, David Asante of the MPP.
But sincerely, don't you think it would be an insult on the court to suggest that what the court has ordered, it's something I'm already doing? You're telling the court that what they did was useless.
No. I don't think it's an insult. If the court makes an order which is in tandem with what you already, I don't think it's an insult. To point out
you would have told the court that already.
No.
So what would have been the need for the court to make specific orders?
The fact, what you ought to examine is whether or not it is true the EC traditionally has done things to clean the register, and whether this time they are doing things that are aimed at cleaning the register and are consistent with what the Supreme Court has said they should do.
So
I don't see that
since
to be
it canvassed that argument in the court, why didn't the court simply say, okay, you have said you are doing all of this already, so we give you the permission, go ahead, continue. But rather than give specific orders and say, do this and do that.
You are talking about the latest ruling last week. Yes, but again,
no, I'm talking about...
Yeah, but again, we have spoken about...
May 5.
We have spoken about ambiguity.
Okay.
In that particular order.
Self-inflicted
the basis
ambiguity.
upon which the applicants themselves have gone back to court to seek direction.
Okay.
So that order cannot become a basis. Please,
I think so.
That order cannot become a basis upon which the EC is criticized.
Okay.
You understand the point? Because the applicants themselves, the plaintiffs themselves, have admitted to that ambiguity by going back to seek direction. Now, in the index ruling, that means the ruling that was made last week, again, there were some things.
Okay. It's okay for you guys to interchangeably use ruling, judgment, and stuff.
Well, what is it?
But they are clearly different. They made orders. They gave directions, so to speak.
Great.
Yeah. A ruling is a minor within a case sometimes.
Fine, no problem.
And the judgment is the ultimate.
Thanks for the education. Now, they've made specific orders for the EC to do A, B, C, D. Now, strangely enough, the very party and its agents who were insisting that there was a certain number of NHIS registrants who are on the register and who should not be there and whose names should be deleted, are now claiming that those same NHIS registrants do not exist, at least in the database of the EC. And therefore, if the EC complied with the Supreme Court ruling, they would have presented erroneous information or false information. What that tells me, and what that should tell any discerning Ghanaian, is that ultimately what the NPP is looking for is a new register, which they have been unable to obtain through the Supreme Court, because the Supreme Court said the register we are using is constitutional.
But is it also fair to suggest that the EC may have sought deliberately to avoid the court making the order for a new register? That is why in courts, I mean, before the 5th May judgment, when it was asked, can you identify these people, it responded in the affirmative.
Yes.
When it knew, allegedly, that it didn't have the capacity to identify these people.
I like your use of the word allegedly. That means that the claim by David Asante is by no means established. You see, the only entity...
I say allegedly because I don't want to put too much weight on something I have not had the opportunity to independently verify.
That's what we should all do.
I have heard the tape, and it does appear that the officials who are speaking there admitting that they cannot identify NHIS registrants are EC officials.
When you go to court...
Amadou Sule and the other woman.
When you go to court, all parties are expected to act on the basis of laid down procedure. The EC cannot go and say by word of mouth that these are the number of NHIS registrants on our register. They will produce documentation to back it.
Correct.
Any challenge thereof must be based on documentation as well.
You're right about
So it does not lie in the mouth of David Asante or his MPP colleagues to accuse the EC of wrongdoing on the basis of some tape. In any event, the MPP itself has constantly disputed the use of tapes to form basis for criticizing them anyway. And leading figures in their party... No, please, let me make a point. Let me make my point.
Hold on.
You have just spoken on the matter.
Make notes.
You have just spoken on the matter. Your flag bearer, your vice presidential candidate, your leading functionaries, Mr. Mark Menu, members of your party have constantly pronounced that David Asante is a member of your party. One of the plaintiffs in the case is a youth organizer of your party. And I'm saying,
what have we pronounced?
You have attacked the credibility of the EC. You have claimed that they are saying on a tape that they don't have the NHIS registrants on their database. You have alleged that they are plotting to rig the election. You have claimed that they have been appalling. They have been irresponsible and all that. Now you are denying it. The point I'm making is that any claim that is made must be subjected to proof and authentication.
And like you said, a very interesting note which I want to hold on and I go to Kokubako is this, that you say, in fact, when they submit the list in court, they will not submit a list out of a vacuum.
Exactly.
They would definitely be required by the court to show
that
how they came by that list. And
so any challenger to that must also present evidence on how they came to the conclusion that it is false.
But I don't remember what the answer was. Thank you. Now, if you're a public service worker and you are in need of a loan, a dire need of a loan, then the place to go is to go to the Bank of Africa. When you go there, you get the loan within 48 hours and you have 3 solid years, 5 years to determine when to pay. That is interesting. And 3 months, you have 5 years to pay and you have 3 months to organize yourself to determine how you go about making the payment. And there are no any hidden charges that you're going to be subject or liable to. Visit any Bank of Africa branch nationwide for further inquiries. Bank of Africa, they are strong as a group and close as a partner. Now, if your internet could speak, what do you think it will be saying to you? It will tell you to dump that particular network that you're using because it shouldn't take you some 4 hours to cook instant noodles. That's how your internet is behaving, and that's a shame. So what you do is that the time is now and a better internet experience is here. You got to switch to MTN 4G LTE and enjoy a whopping 100% bonus when you bundle. To get started, simply dial *585# to check if your device is 4G compliant, and then visit any MTN service center near you with a valid ID card, perhaps including NHIS card, and make your switch today. Enjoy a better internet experience on Ghana's only 4G network on the go and say hello to the future. MTN, welcome to the new world. And Star Assurance, you know them. They're very credible, very reliable. When it comes to insurance, they've been doing this job for 30 years. And all these years, they have made their customers feel as though the dangers and the perils that we are subjected to in life naturally only exist in the dream world. So where else to go for your insurance than Star Assurance? If you want homeowners, contractors, all risk, fire, and allied perils insurance policy, the place to go is Star Assurance, where you will smile. Log on to www.starassurance.com or visit any of their offices nationwide. You could also call them 030-224-0632 and enjoy solid insurance all year round. I will take my time to tell you about some other interesting products that you need to hook onto shortly. Now, Kweku, first of all, what do you make of the court's posture, the posture of the judges? We read the report. I was not in court, but we read the report from almost all the media outlets, and the journalists say, without mincing words, that the judges were visibly angry, one after the other, seeking to tell the EC that they seem to be taking us for a ride as a nation. What do you make, first of all, of that posture and the orders made to the EC?
Well, you're right. I was also not in court. It's the media reports that I've read. And despite the fact that I'm a journalist, these days I'm very cautious in proceeding on basis of media reports and what they say. I myself have become a victim of such misrepresentations and things. But so far, I haven't
but it's safer if you have all of them saying the same thing.
Yeah, but I haven't heard anybody contradicting, especially from official sources, judicial service. So I'll proceed on that basis, though cautiously, that what you are presenting is what happened in court. Did we have to arrive at this stage? Did we? We're painfully, this is a very painfully slow transition to a solution relative to the integrity of our election system. There was a time I said here that if there had been goodwill and good faith, we might not even have landed in court and pursue a litigation relative to this matter. 2-3 years down the line.
Kindly speak up a bit for me.
2-3 years ago, if there was good faith, goodwill, common sense, we may not have gone for litigation on these matters. But you see, unfortunately, this whole thing became very politicized. Not political, politicized. So here we are. We've arrived at another stage where there's even confusion as to what the court did or did not do, and whether those things are feasible or not feasible. Look, after all those legal gymnastics and the propaganda masturbation, excuse my language, in the wake of the May 5th judgment, the orders that were delivered, here we are. The court last week told us that in terms of the what, it was clear as to what it had determined ought to have been done. The how was where there was some dispute among litigants and debaters and all the rest. And that's why the court says you come with a list of those who registered with NHIS or NHIA cards. That's the what. That was clear. And yet there was all sorts of arguments and, needless debate on that aspect. The guidelines, bring the guidelines. How are you going to go about it? And this was critical because, you see, the EC had created an impression that, oh, come on, applicable laws, existing laws, whatever those two things mean. And that CI 91, we are going by exhibition. We'll do it this way, we'll do it that way. Bring it. Now, and some of us indicated that the so-called existing laws cannot cure the mischief that the Supreme Court had identified. How am I going to go out there during the exhibition and say that this man registered with NHIS card? How am I going to know that? I may know one or two people, maybe close to me. But the millions, and don't forget, in the first Abu Ramadan case, the AG's argument was to the effect that a broad section of Ghanaians had used NHIS cards to register, and that if the court actually took it out, it would deprive a broad section of Ghanaians and disenfranchise a majority of potential voters. So then we got an idea of the scope and the coverage of the problem. Who else can do that identification? Only the EC. They have the database. I'm getting worried. I'm getting frightened to hear of the possibility that they don't even have that captured on their database. That's worrying. That is frightening.
And what Kweku has said, you may have heard David Asante also refer to it, that Nana Kumia referred briefly to the Attorney General's contention in the first Abu Ramadan case. And I just want to quote for purposes of making it double sure that that is what it is. The AG has said in its written submission that, quote, it is submitted that to remove the NHIS card from the list in Regulation 1.3 of CI 72 will amount to depriving a broad section of Ghanaians of their right to vote, unquote. This is found in paragraph 6 of their submission. Again, in paragraph 15, they said, quote, to eliminate the use of NHIS card in Regulation 1.3 of CI 72 will mean to disenfranchise majority of potential voters, unquote. So they use those two words, broad section of Ghanaians and majority of potential voters. Let's go on.
So there we are. So we are clear in our minds, at least based on the record of proceedings before the highest court of the land, that we are dealing with a gargantuan challenge, a big matter. It's not 10, 15 people who registered with it. It's not some 100,000. It's massive, big job there. Why all this delaying, protracted transition towards a solution that we could have resolved years ago? I'm very disappointed as a Ghanaian.
From what we are being told, was this a speculation by the AG that there was a broad section of Ghanaians or a majority of Ghanaians who had registered with NHIS card? If we take what we hear in the conversation between Nana Asante Bediatio and the Electoral Commission officials who said they are unable to identify NHIS registrants.
There's a line of distinction, a very fine line of distinction between the two.
Right.
When the AG was making that submission in the court of law, they were on the side of the EC. They were all were the defendants in this case?
Yes, they were defendants.
Yes, I'm not aware if the EC contradicted that.
No.
So I assume that the EC believed in what the AG was saying, and that was before a court of law. Okay? Now, subsequently, the meeting with Asante Bediutena, it's looking back, but the court was right, perhaps not to admit it because of the way it was procured. Even though I know in some circumstances the court could have. I don't know, I leave that judgment. I would wish, instinctively, I thought they should have admitted it and scrutinized it based on its value. They didn't do. So that thing, that tape, is not on record before the court. I don't know, you are the lawyer, whether the court can subsequently decide that we need to listen to this tape for whatever value it brings to bear on that matter. I don't know.
It may be difficult. This is the Supreme Court, but it may be very difficult. And again, how they did the recording, I think, is the major issue.
That's the point I was making. But
it is true that the Constitution says in Article 18 that when it is the recording, for example, is procured for the purposes of preventing crime or something like that, then it may be admitted for some purposes.
But this recording could expose perjury, could expose things. It could be in the interest of the public.
But it must come from the right custody.
Yes. You see, I'm here talking as an illiterate on this matter.
Yes, proceed.
Uneducated intervention that I'm making. I leave that to those who have better insight, deeper insight into these matters. But that's a real gray area. Now, that one, they were now talking of whether you have that thing on the database and you can provide the information. It's different from when the AG said, we have all these people there, and that if you took a decision that would delete them, it can affect their constitutional right to vote. I think I draw a fine line of distinction.
Okay.
That's my point. But you see, to be honest with you, I don't know. I may be running into some areas. I'm beginning to think that perhaps if we had opted for a new register 2 years down ago, we may have cured this mischief. We may have cured it.
Would you say that the defendants in this case, the Electoral Commission and the Attorney General, throughout the process, sought to lie to the court to avoid being ordered to do a new register?
Lie is such a very, very loaded way of putting it. I think that perhaps they were economical with the truth. Okay, yes, I feel sorry when I say these things about institution of state. I am known to have given the EC a lot of support over the years after our early days of bashing them, 1992 to 1994. Subsequently, that I've been a very powerful advocate for the EC, including this one. And I've just found out in the last few weeks that the chairperson is actually even very, very close to me in terms of blood relationship. I didn't know.
Conflict of interest.
Yes, I didn't know. Only the last 3 weeks.
Okay.
Very, very close. We are family, which I didn't know. So now here I am, I'm a bit cornered.
Has she given you a vodka?
Oh, come off it. You see the mischief. So, yes, there's a conflict of emotions and passion and things there. But the truth must be told.
Yes.
I think the EC has become part of the problem. And when they return to court on 29th, is it 30th rather?
30th.
Another very significant day.
Right, Matthias Day.
In the history of the judiciary. And they bring the list. The list ought to be subjected to strict scrutiny in terms of its authenticity and credibility and integrity.
Okay.
And then 2, the guidelines they bring, I anticipate, and this is the important point about the thing of the independence of the EC and how they work. The Supreme Court appears to have respected that in a certain general terms. But now when you bring the guidelines, and the guidelines cannot cure the mischief that was identified in the what, it is then within the remit of the highest court of the land to tell you what exactly to do. I anticipate that perhaps we may be heading towards the need to amend, not repeat,
CI 91.
and make sure that we put in place an appropriate constitutional instrument that we can apply to cure the mischief that has been identified in the what.
If you look at CI 91, the specimen, the schedule, the Form 1A, you see how different it is from the previous one.
Yes.
In the previous one, you were only to state if you are using national identification card. But in this one, you are supposed to indicate which particular card you are using. So that if we had something like that earlier, it would have been very easy to identify the NHIS registrant.
Yes.
Because the CI, the Form 1A, the one that was used in 2012, you don't go to the registration center and indicate the particular ID card you are using. So you realize that in the tape that some of us have listened, you realize that Nana Santipideto was suggesting that maybe the way to identify the NHIS people is to look at the numbers of the card that is written there. but it does appear that you may not also find that on the document. So it looks like it's going to be a very Herculean task.
I agree with you. It's a challenge. I remember the day Tarzan joined us here.
Right.
We even began to think whether this was not a mission impossible. If you recall,
Yeah.
when we looked at the full parameters and things. But you see, that's why I said then perhaps a new register would have cured the mischief. Or this validation team which the court rejected, they may have to look at it again. But they can do that only on basis of review. I don't know. You are the lawyer.
Okay.
But you see, Justice Benny, in his concurring opinion, if you recall, also pointed to a defect even of CI 91 in terms of the need to capture the form of identification you use on the database, which he thought was missing. That it was missing in CI 72 and was missing in CI 91. I was trying to look for the paragraph and read it out.
I thought that there was, I heard something like that. I thought there was quite a sufficient cure in CI 91. Far improved.
I am not, improved, yes, but not sufficiently improved.
Okay.
I'll find it later and read it.
In 30 seconds, do you suspect that we may get to a culminating point where the court will say, if we cannot trust the list you are bringing, and it is on your assurance to us earlier that you could have the list, that we decline to make an order for a new register. Now, if you can't produce that list, then let's have a new register. Do you suspect that this is a possibility?
Well, you said suspicion. I wish it happens.
You wish?
Yes, that would be my wish.
Would we have time?
Why not? Tight. We'll be walking a tightrope. But who tells you we can't compile a new register in 3 months? Who says we can't?
Okay.
That means that perhaps we'll have to review the November 7th thing and go back to December 7th.
November 7th obviously sounds
it's not law
appears
yet,
to be in limbo. Yes. Yeah. Obviously appears to be in limbo. Now, before I come to Doc, the having insecticides, mosquito coil, and the things that they produce to you, they now have a newly improved, stronger formula for their products. The mosquito coils now have a stronger killing formula to knock off any kind of mosquito. Even big macho mosquitoes can't survive the new improved formula. Also, the new one has a smoke reduction formula. Therefore, it doesn't give colds or coughs or catarrh. Again, it has a unique sweet-scented flowery perfume, which gives you a very pleasant experience. Now, when it comes to the insecticide spray, what you find in the new insecticide spray is that the spray is now with a stronger killing formula against all flying and crawling insects. New improved Heaven Plus mosquito spray has also a unique sweet-scented perfume. So you just need that. So having insecticides that's gentle, pleasant on humans, and a tough nightmare on insects, you need to get having insecticides. Having insecticides, that's the best that you can find on the market. Now, as a farmer, landscaper, or gardener, what has been your bother or headache over the years? Is it about poor seasonal yields over the period, post-harvest losses due to short shelf life of the produce? Then you need ACAP compost fertilizer. ACAP compost fertilizer is an organic fertilizer made from pure organic materials such as food, market and farm waste decomposed naturally into humus like compost, very suitable for agricultural purposes. ACAP compost fertilizer has very high organic matter other than nutrients, good water retention properties, ideal for all crop including vegetables, fruits, cereals, crop trees, and cocoa, such as cocoa, palm, coffee, cotton, and greening, etc. ACAP compost fertilizer is available in all leading agro input dealers and distributors across the country. You can call Boafo on 0264 0708 081 or Theophili on 0201 735 564 or Brantio on 0243 473 158. That is ACAP fertilizer, compost, and recycling purposes, you can contact them. Is the best that you can find right now. Now, Doc,
yes. I'm sorry.
Right.
Pardon me. Just indulge me. The Justice Bennett thing. This is what he said. This is on page 44. He says, I would take this opportunity to comment briefly on CI 91. In view of all the happenings in respect of the eligibility criteria of potential voters on the register, one would have thought that any change in the law would have made provision for the form of identification used by a registered voter to be captured in the first defendant's database, that's the NHIS database. This would have made it easier in future for the court to make definitive pronouncement on the status of persons whose names appear in the voters' register. It is sad to recall that CI 91 has been published without this important information. It is good to draw lessons from court decisions in order to inform future conduct of state actors. Regulation 22 of CI 91 did not improve upon CI 72. If this court's decision do not guide the future conduct of state actors, then problems of needless litigation would never be stopped, and the country will be poorer for it. An offshoot of court decisions is to provoke and influence change or reform in the law to prevent or reduce future litigation and conflict, quote unquote.
Thank you very much. Now, Doc, I mean, sitting, observing all that is going on, do you think that we are working towards avoiding what Dr. Kofi Annan says we ought to avoid? That we should not let the streets take the place of the ballot box, and that the only way to ensure that is credible elections?
Yeah, thank you very much, Samson, for the opportunity, and I want to congratulate my panelists, senior colleagues present. Let us also acknowledge our viewers and listeners. This is a unique opportunity to comment on very sensitive issue as elections. Kofi Annan's point was clear that we should not allow the street to take over, the ballot. Fundamentally, let me state that excessive partisanship will undermine our democracy. Excessive partisanship will undermine our democracy. I think that there must be a basic consensus, especially a late consensus, on some of the critical things that will govern our lives. I was thinking that something as fundamental as voters register, credible voters register, should not divide us at all. There must be consensus on what really must be a credible voters register. If all of us have decided that democracy should be the only game in town, behaviorally, attitudinally, constitutionally. It is not for nothing that the Constitution has crafted for us various institutions of state. And I think that the framers of our Constitution, and most constitutions for that matter, have taken a cue from John Locke. That where the law ends is where tyranny begins. And one of the surest ways you can avoid the excessive exercise of discretionary powers and, of course, its attendant problems is to make sure that you reduce the number of transactions over which public officials have discretionary power, so that there will be some form of stability, that you can predict the actions of government, then the individuals can be safeguarded. Why? The Supreme Court has played critical roles in the history of the world. If you go to the U.S. history, Marbury versus Madison, which gave them what you call the whole concept of judicial review. You are interested in Roe v. Wade, you go to Brown versus Board of Education. If you are looking at Gideon versus Wainwright, if you are looking at the Miranda warnings, among others. Even if you come back, into our own republic.
Constitutional law class.
And you are looking at our own Fourth Republic, and you go back to 1993, where the MPP decided to challenge, take the GBC also to court over the decision as to whether they should be allowed to debate the budget, etc. In 1997, I think J.H. Mensah had to go to the Supreme Court to check whether indeed retained ministers still go through vetting and so on. And then I think the ruling was that they needed that prior approval, except that prior approval was not a term of act. and so on. I mean, the argument was that we've had live president, and therefore we don't need live ministers in this country. We moved on. If you fast forward to the year 2000, the NDC was in court, challenging the decision to use just only the photo ID card for the elections of 2000. And then the court ruled that no, we're going to disenfranchise people with a thumbprint ID card, which perhaps was still valid at the time, which we went through. Fast forward now, we have Supreme Court even determining that, or indicating that prisoners can vote, among others. But in all of these cases, you realize that whenever the Supreme Court has made a pronouncement, even though it takes an administrative agency of the state to implement, they have expanded the frontiers of constitutionalism. They have expanded the frontiers of democracy. They have broadened the scope of fairness, and really expanded public policies and programs that eventually inure to the benefit of the rank and file. Why are we here? And that is why I talked about excessive partisanship. Now, if you look at the dynamics of our politics of the state, we were thinking that institutions of state, even though the EC must enjoy some high level of independence. I'm not saying that you need to enjoy that independence to the total, disadvantage of all of us. Why not? You listen to the various consensus, various shades of opinion, because fundamentally you derive your authority from the state. And so if the state of Ghana is in trouble, the EC is in trouble. So it is important that we must be guided by the public interest concerns. That for me is critical. We don't have to. We have agreed that democracy should be the only game in town. Elections are critical. I don't think that you can have any democracy without viable elections. Even though we can have undemocratic elections, there's no democracy that you can really talk about that has no elections. But the elections must be credible. And the voters register, for instance, is fundamental because it determines who will win, for instance. It determines fundamentally who has the right to vote. Anyway, so critical. And I have always argued that, and on several platforms, that if there is even a vote in my bedroom or there's going to be an election in my bedroom, I will vote because it gives me a unique opportunity to really decide on some fundamental issues that govern my life. Those who have a right to vote, it's a democratic imperative that those who are affected by a decision must have a way of actually influencing the decision. Supreme Court rulings, among others. I was thinking that if we are taking steps, and this, I subscribe to the position that Andre Kwekubaku, raised, that if we are taking steps to deal with the fundamental issues that the Supreme Court had raised, as far back as 2014, we won't be where we are. And I think that the EC owe it a duty to be much more responsive to the needs and concerns of the people. Why can't major political parties, with all the good intentions, craft a consensus for all of us to remain useful, to continue to demonstrate that indeed it's not just partisanship for its sake, but indeed we are also governed by the national interest. Well, of course, it's a numberless concept, but something as basic as a credible election must be a national interest issue that all of us must be concerned with. So I think that we are walking a tightrope. We shouldn't be where we are because steps should have been taken, because I think the first directive or the first order was that the EC had to take immediate steps. Immediate. That word was immediate. And so the moment one of the deputies indicated that the EC already had a timetable, I said to my student, this is a recipe for disaster in this country. Not disaster in the sense that people will go to the street, but I was very sure that some people will go back to court. And perhaps once you begin to prolong the process of litigation, then we are really boxing ourselves into a corner as a people. We've been known to be organizing relatively free, violent-free elections, free and fair elections over the years. We've made progress down the line. We have had 2 power alternations in 2000, 2008. We are not hopeless people. There's a hope for this country. We demonstrated that given the opportunity, we can hold our own in the international system. It's not for nothing that Obama came here and used Ghana as a platform to launch his policy on Africa, etc. If you look at what we have enjoyed under the Millennium Challenge account, for instance, where we had, the first one was about 547 million United States dollars, and now we are getting very close to, I think, $500 million. It's not for nothing. The fundamental guiding principle, I think, in all of these was the fact that we are good boys in the international system as far as good governance was concerned. So for me, the key stakeholders must be guided by what we have done over the years, our records, and must not lower the bar. And that's why I said that excessive partisanship will undermine our democracy. I think that we still can pull through. We still have the capacity. Why not? I'm a rational actor institutionalist, and I always insist that even when the institutions are not doing well, we need to help them to grow, because they go through what we refer to as a path of dependency. But they are validated by both internal actors and external actors. And that is why when we comment about the operations of all the Electoral Commission, the Supreme Court operations among others, look at the judges and the justices of the Supreme Court and what they have said, that they would not allow, for instance, the EC to plunge this country into chaos. That, for me, it's huge statement that they have made. What it means that, I mean, as a court...
And they seem also to suggest that things are happening, and in the end, they will be blamed, and
Precisely.
that they do not want to take any blame in this.
Precisely, because when people are, when we have crafted for ourselves a constitution, so when there's a problem, people will still go back to court, and they may have to spend sleepless nights trying to adjudicate and make sure.
What do you say specific to, let's say, it's the NPP really, because you can't run away from that. It's not just Let My Vote Count Alliance or the plaintiffs in this case who are crying in this manner.
Yeah.
What do you say to them in respect of the new challenge they are seeking to mount, even where the EC says, I have the capacity to produce what this court requires?
Yeah.
What should be their approach?
Yeah, I would expect the NPP to still be a loyal opposition and also be guided by the national interest. They've indicated throughout, I think the beginning of the year, somewhere last year, they indicated that there was serious problem. I think from 2012 down, that there have been serious problems with our voters register, and therefore, I think the major conclusion was that they were pushing for a totally new register. It's not always that you get what you want, but sometimes you compromise, but not compromising cheaply that will undermine your fundamental principles. So in all of this, we must still engage the system vigorously, but at the same time, trusting that we have institutions which are capable. Okay. Because a EC, a body, a constitutionally, what do you call an election management body, which has been able to deliver two power alternations, cannot be demonized. We need to still give it, the chance, and of course support it to be able to deal with the things that they have to deal with. Okay. But in all of this, Samson, quickly, that we are interested in three fundamental, concepts. We are talking about accountability here. We are talking about transparency here. We are talking about trust. These things are critical in enhancing our democracy. If, for instance, you want to or you want to pitch, let's say, accountability and against trust, you will say that some will argue that trust without accountability will be a blind trust.
Right.
And then some will also argue that accountability without trust will also be like an inquisition. So it is important that as we enhance the transparency of the system, we make the system much more transparent and accountable to the needs and aspirations of the people. Because for me, if you shifted the EC from Ghana to Togo, it's not the EC of Ghana. And that's why I always believe that fundamentally they derive the authority from the state. There are certain universal concepts that you don't go to the classroom and debate on it and perhaps vote on it as to what constitutes an even number or prime number. These are universal concepts.
Right. Okay. Yes. I'm just picking a minute each from you, and then we take a break and return to deal with the other matters that we have. From Nana, particularly from the presentation made by Kweku and Dr. Evans Adre, what do you think? What do you think your party can do to support the process in a way that, in the end, we will all be the beneficiaries of a peaceful election?
Thank you, Samson. The NPP is already engaged with the Electoral Commission at the IPAC level. And so it's not specifically just the NPP. When the Electoral Commission brings the issues to IPAC, I'm sure the party would have wonderful contributions on the way forward. So that is what we expect from the Electoral Commission. Now, the NPP as a party has not said anywhere that the Electoral Commission will not be able to produce the list. We haven't said anywhere.
You're right about that. Officially, no.
What I have said here this morning is that The Electoral Commission says it will produce the list. It has a couple of days. So we'll just wait and see. When the list comes, we would all be interested in the integrity of that list.
Right.
And then we'll take it up from there.
Okay.
You asked me a specific question that what Let My Vote Count was talking about, the inability to produce the list. And I said, they may have some justification. And I gave you instances, the record. I don't know if you have the tape.
I said I have it.
Okay,
Yeah.
maybe if you have a bit of time, just play it.
No.
And look, I can also show you transcripts of a meeting that was held at the Electoral Commission's conference room on the 30th of March.
I gave you a minute, so do it quickly.
Where the Electoral Commission, in the person of Mrs. Amankwa, stated clearly that it will be difficult. Say, as the register stands now, we cannot identify the people.
And this is a transcript. I'm not in a position to verify. So,
but my brother Felix made a terribly unfair charge against Mr. Abu Ramadan.
Finish on that point.
If you were to go by Felix Kwache's inference that Abu Ramadan is serving the interests of the NPP, then clearly the Electoral Commission of Ghana is serving the interests of the NDC, because at every stage in this process, the Electoral Commission's take on the issues agree perfectly with the take of the NDC. So, Felix, please don't go about making this baseless accusations.
Let's hear you also. What's the commitment really of the party, the NDC, and the government, where now people are becoming a bit suspicious that almost everything every step the EC takes is okay with the NDC?
Well, that suspicion ought to be dismissed with contempt. You see,
Abu Ramadan.
Nana, stop.
the NDC is a stakeholder and a major stakeholder in this election as such.
Sure.
Indeed, it would interest you to note that when this whole caboodle started, when the MPP went to serve the EC with their so-called evidence on the flawed register, they served copies to all parties, including the National Democratic Congress. That was an acknowledgement that there were other stakeholders who needed to have a say in what was happening. We reserve the right as a party to fend off what we believe to be unjustifiable attacks on state institutions that should conduct elections. We are by no means spokespersons of the EC. Indeed, we have had cause in the past to criticize the EC. But what is happening now is on a level that is unprecedented. The New Patriotic Party, directly and through surrogates, has sought to mount an insurgency against the EC. They have made allegations, some of which have proven to be blatantly false, in a bid to show that the register somehow
very symptomatic of what opposition parties do, right?
Absolutely. But the point is this, that state institutions should not position themselves such that frivolity becomes the order of the day. We should not have a situation where every electoral cycle, some party calls for a new register because it believes that it favors its interest.
Okay.
That's why I'm saying that let the parties in this matter prove beyond doubt that the electoral rule is indeed flawed before a pronouncement is made on it. Again, it is premature for people to conclude that merely because the Supreme Court has asked the EC to furnish them with some information, it means that they are going to arrive at one conclusion or the other. I think that we should wait for the ruling before we make.
You're right about that. Thank you.
Yes.
Thank you. Kuku. Someone made. Thank you. Sorry. Nana, stop. Nana, stop. Nana.
This insurgency that first.
Nana.
This is a party that actually went and besieged the electoral commission.
Stop. Nana, stop. Please. Sorry about this. Kuku, let's hear you.
Be fair to the facts.
Yeah, I'm fair to the facts.
Let's hear you, Kuku.
For 3 days.
Nana, sorry. What you're doing is not good. Yeah.
But you appreciate the point, Samson.
Kuku, let's hear you. Yeah. What should be the posture
of
parties and the EC?
No. What will happen at the Supreme Court is what will determine the way forward.
Okay.
Whether we like it or not. The trajectory is clear.
Okay.
It's painfully slow transition to the destination. Very painfully slow. But we are getting there.
Okay.
Bring the list.
Okay.
You said it's possible to get a list. Bring the list. We should make sure the list is credible and has integrity. Bring guidelines. We will determine whether the guidelines can cure the mischief. If it cannot, the Supreme Court can tell you what to do.
Correct.
In spite of your independence.
Right. The Constitution is clear about that. The Supreme Court can tell you what to do. For those who suggest that the Supreme Court cannot tell anybody what to do, go check your Constitution properly. I think Article 259 or somewhere thereabout you'll find it very clearly. And maybe just a footnote that when the court sat on Thursday, the Justice Jones Doche recused himself, and the allegations and information all about the place is that he did so because of his public comments. Now, I want to put on record that the official information I have is that it has nothing to do with his public comments, but that this new application, when it was brought at a time when one of the judges who sat on the original case had retired after the judgment, Justice Akamba, and that left the panel, reduced the panel to 6. They always require an odd number. So one person ought to have stepped down to leave a panel of 5. Then he voluntarily decided to check out. Thank you very much. We take a break.
I think if that were not the case, he should have accused himself still because of the comments that he made.
Okay, but that would be speculative. Yeah, that would be speculative.
I'm stating a position. I'm not speculating. I'm not saying that is why he did so, but I think he should have.
Thank you very much. Thank you very much.
Some mischief is out there on social media.
Okay, thank you very much. So let's take a break here. We'll be right back. You're welcome back. This is Newsfile, your most authoritative news analysis show, brought to you by the kindest sponsorship of Bank of Africa, strongest group and closest partner, MTN. Welcome to the new world. Star Assurance, creating smiles since 1985 and celebrating 30 years of solid partnership. NIIT, bringing people and computers together successfully. Having mosquito coil, having Obutantim, Accra Composts, Fertilizer, and White Temple Agency, a luxury you can afford. Charles Kumsin in Medina says, what happens to those who were guaranteed by those who got voter ID cards with NHIS cards? The net will catch more fish than expected. And why is the NDC so scared of taking NHIS card holders out of the register? Musa Batoa in Kumasi says, Ofosu Kwachi is on point. If you have opposition who lost policy direction, expect this kind of attacks on the EC. What the NPP is doing is clearly an agenda to prepare the minds of their supporters to reject the outcome of the November polls. EC is yet to provide list, so why are they crying foul? Well, you would also note that while it's been noted that one of the grounds for a possible challenge of the elections results will be if the court's decisions or orders are not implemented to the letter. Now, Benjamin Osei Jamira in Edinburgh in the UK says that the EC has been very stubborn and has demonstrated a high degree of lackadaisical attitude towards the performance of its constitutionally mandated duties. The EC better not go to the court with any funny stories. They should produce the list as demanded by the highest court of the land. We are waiting for them. The EC cannot do what it wants in the name of independence. They are there for Ghanaians and in our interest. They shall work not the interest of any political party. Oliver Bamba says the EC's increasing posture of we saw it, we picked it, and we liked it, and it makes us happy is what has led us to where we are today. Alexander Intakrade says, please may I know if all NDC communicators speak for the EC. Of course, I'm sure you know that it's not. Yusuf, MPP have started another unnecessary allegation again. That's all you want to say. Bonti Benjamin says the EC should stop buying time and respect the court order to save us the fear and panic. Ghana bread change we need now. Okay, thank you very much. Now,